Thank you for your talk and your personal efforts in trying to bring these changes about. I really appreciate that. I know that King Richard and King George W. don't really listen to inputs from other people, and I know we're very independent-minded, but there are people who've been dealing with terrorists and large-scale threats for quite a while. The French, for example. I know that their legal system is a little different, and they do have special judges that are kind of sitting in corners. And of course, they have the Napoleonic Code, which is a little different. But they've been dealing and adjudicating, and these people are imprisoned for various times through the courts. They use a lot of information from Arab countries and from Interpol in particular, which, again, the President administration doesn't like to take inputs from. But I just wanted to, as a suggestion, have you studied that? I haven't read enough about it. Has this been studied? Is there any kind of paradigm like this? We certainly could, in this case, learn from the French. Thank you.
Absolutely. No, that's a very good point. And in fact, 3 weeks ago, I was at a conference in Europe which was meant to share experiences, share knowledge. So it had a bunch of American participants and also a bunch of Italian, French, Spanish, and other European participants, including judges and prosecutors who handle terrorism cases. And the Europeans were unanimously aghast at the American approach of the past 6 years. And they made the point that not only has it harmed the U.S.'s own efforts to fight terrorism, but in fact it's harmed European efforts, because some of these people were and are wanted in European courts. Some of these people have information that the Europeans could have used. And in fact, there was a very important case in Hamburg, I think in Hamburg, and somewhere in Germany a few years ago, in which the case needed information that Ramzi bin al-Shibh had. Ramzi bin al-Shibh, as you probably know, was held in CIA custody for several years. And the U.S. refused, of course, to provide Ramzi bin al-Shibh or his testimony to be used in court, and it almost led to the acquittal of some dangerous people in Germany. So I think the European experience is a really useful experience for Americans to look at. The European experience has been to prosecute these cases and to successfully prosecute these cases. And in terms of a negative European experience that I think is also instructive, when we're thinking about experimenting with preventive detention, we should look back at the UK experience of holding members of the Irish Republican Army in preventive detention during the 1970s, what was called internment. That experiment is absolutely widely seen as a failure, and people in the United Kingdom on both the right and the left agree that interning these suspected terrorists did not harm their organization, but in fact led to greater recruitment. It elevated their status. It was a boon to them, as opposed to part of an effective effort to defeat them.
Good morning.
Good morning.
How many prisoners are being held because of the state secret privilege? And please, if you can, give us an update on the 20 CIA agents on trial and abstention in Italy.
Well, the state secrets privilege has been used. When we spoke about compensation a minute ago, there have been some efforts in U.S. courts to bring suit for violations against people who've been held in abusive CIA custody. So you may have heard of the case of Khalid al-Masri, who is a German citizen who was abducted in Macedonia and brought to a secret CIA prison in Afghanistan. Also the case of Maher Arar, a Canadian citizen who was sent to Syria to be tortured. They brought suits in U.S. court for compensation, and those cases were tossed out based on the state secrets privilege. So it's essentially been used as a shield, and not just a shield in a way that possibly might be at least somewhat legitimate to protect against the revelation of classified material. No, it's been used as a shield to just absolutely throw these cases out of court, which is extremely disappointing. Now in Europe, Europe right now, or Italy in particular, is the only place in which there is some effective effort at accountability. And I was actually just in Milan 2 weeks ago to see the first testimony in what's known as the Abu Omar trial, which is the trial of 26 Americans, including 25 CIA operatives, as well as a number of Italian intelligence officials who are allegedly responsible for abducting an Egyptian cleric in Milan and delivering him to Egypt, where he was held in incommunicado detention and badly tortured for a period of years. That case is going forward, and in fact, that judge is one of the judges who's been most critical of Guantanamo and of U.S. Counterterrorism efforts.
Joanne, we have time for one more question.
Okay, well, great. One last person.
As I listen to your presentation, it seems like to me that there's one thread that is easy as a starting point to pull to bring back some respect to justice in the system, and that is the elimination of this secret evidence and making that available and transparent. You don't have to, as a first step, that cleans up a lot of things going forward. Why isn't that being done?
I could not agree with you more. I think that's really basic, and it's sad when you read the transcripts of the status proceedings at Guantanamo, how many of these detainees say, okay, you say that I was in this place, or you say that I'm a CIA operative, Al-Qaeda operative. Who said that? You know, how can I rebut this evidence if you won't tell me who's making this claim? But at Guantanamo, it's secret evidence. Proposals for preventive detention would likely be based on secret evidence. Secret evidence is inherently unfair. Secret evidence is inherently something that the person who's facing accusations cannot effectively rebut. So I think we absolutely need to recognize that any system by which people are detained based on secret evidence is unfair. Thank you.